Well, on behalf of the Hoover Institution and our partners at the U.S. Patent and Trademark Office, we'd like to welcome you to this symposium on what the Academy's role is in evidence-based policymaking for intellectual property. Also, I'd like to welcome the millions who are joining us over the internet for this session. My name is Richard Sousa. I'm from the home office at Stanford, and I have to admit I'm not used to this weather, and that's why I stay at Stanford. For those of you who don't know just a bit about the Hoover Institution, we're a research center at Stanford University. We look at economic and political and social change in the modern era. We take a lot of attention looking at the research, pay a lot of attention rather, looking at the research and trying to see what the implications are for public policy. And at Hoover IP2, something that my partner Steve Haber and I have been doing for a couple of years now, we take a more specific look at intellectual property, and we've really focused on patents on the last 2 years. We could be expanding beyond that in the future. And we've been here in the DC office here, this particular office, for a couple of years. We've had an outpost here in DC for about 7 or 8 years now as Hoover has expanded and increased its productivity and its prominence here in Washington, we hope. What Hoover IP2 is trying to do is we're trying to do a few things. One is to endorse research and support research. A lot of research, particularly on patents, is not based on the evidence and reason that we like to think is important for social science research. So we've really taken a lead in trying to do that. We're trying to build a literature in that area. We're trying to build a group of scholars, an interdisciplinary group of scholars who will be working in that area. And we do that by conferences and symposia like these. The conferences we typically do at Hoover. We support basic research in this area. In addition, we have a working paper series, and we also do a summer teaching institute at which we bring young scholars and young people interested in public policy and in intellectual property out to Hoover for a 2-week series and a session of lectures, and that has been productive. We feel one of our alumni is here with us today, and thank you for coming. And I think that's basically mostly what we're interested in. As I said, our goal is to push forward research. We have a visiting fellow program. We provide young professors with summer months for research in this area. So our goal is, as I said, to advance the literature in this area. And so question asked, why are we doing this? Well, we think the stakes are really high in intellectual property and in patents in particular. And we're worried a lot that decisions are made not based on evidence and data. And so we're trying to bring those two elements into this whole project that we are undertaking. So, with that said, I think we're ready to go forward. Before I turn this over to the people who are doing on the intellectual work on this, I want to thank a number of people. Paige Mathis, Amy Palguta, and Matt McCollum here at the home office, here at Hoover. Anna Maria Prati, who's I'm sure watching us in California, has been very helpful. And then, of course, the whole USPTO team has been very helpful, starting with Alan and Shira, who helped generate this whole project. Also Sarub, who is here as well, and then a few people who apparently have not quite made it, Janet and Jennifer. So I want to thank all of them at the USPTO. This has been a great relationship, and I expect it's going to be a good day. So the Chief Policy Officer and the Director of International Affairs at the U.S. Patent and Trademark Office is Shira Perlmutter, and I will let Shira say a few things about the Edison project, the Edison Visiting Scholar Project, and that's probably why we're here. So thank you.
Well, thank you very much. I'm personally delighted to be here, and the PTO is especially delighted to be partnering with the Hoover Institution to organize this conference on the important and timely question of the Academy's role in evidence-based IP policymaking. That is an issue that the PTO has been focused on and engaged with for several years now, starting at least back in 2010, when we established our chief economist's office and started to formally advance a full-blown economic research agenda. So during that time, in the past 5 years, we've held over a dozen conferences, hosted over 24 visiting speakers, and since we're part of the Department of Commerce, we're very big on metrics, so I have to get the numbers in. And we've also, more substantively, produced a wealth of data to support academic research and to inform the work of the PTO. The work that our Chief Economist's Office does is relevant to our operations, it's relevant to our budget, and from my perspective, it's particularly relevant to policymaking. And of course, in addition, it helps to further the public discourse on all of these issues. In 2012, we established the Edison Scholars Program. The genesis of that program was really Dave Kapos, who was then the director of the Patent and Trademark Office, his interest in working with the Academy. He had brought in a number of prominent academics to serve in high-level advisory roles in the office, as well as Stu Graham, who was our first chief economist. And that coincided with my own interest in the area and my background, having spent 5 years in the Academy full-time. So we started with the idea in 2012 that we would bring in one or more distinguished scholars who have been working in the field for some time and were well known, and have them spend time pursuing research projects of their own for which it would be useful to be able to interact with PTO experts and have access to a lot of data about how the PTO operates. We also thought it would be beneficial to have essentially these people working in-house, either part or full-time, to be a resource for all of us, to participate in policy discussions, to lend their views and their voices to the issues that we were debating internally. So overall, the goal for the office, for the PTO, in establishing the program was so that we could benefit from some of the deep thinking that these academics could bring to bear, and allow them to come in, get insights that they might not otherwise have been able to have, and then to potentially have the opportunity to approach issues and problems in a different way than might have occurred to us working immersed in day-to-day operations. So I think the program has been tremendously successful in the 2 or 3 years that it's been in operation. We were off to a stellar start with our first Edison scholars. We started with Jay Thomas, who looked at the administrative modernization of patent disclosure. We brought in Peter Manel, who looked at best practices for claim clarity, and also, this may be of more interest to me than to most in today's audience, but he also looked at online copyright issues and was a very helpful advisor on the copyright green paper that we produced in 2013. And we brought in Jay Keeson, who worked on harmonization and cross-country comparisons of patent examination. All of these efforts produced very helpful research and proposals. And then in 2013, the Patent Office and the White House and the entire administration and the Hill, obviously, became engaged in looking very seriously at patent reform issues, primarily relating to abusive litigation. And as part of a series of executive actions that the White House announced, the Patent Office expanded the Edison program to bring in academics to study specific issues that bore on those topics, on the issue of patent litigation and its potential abuse. So that was the first time that we essentially came up with the topic rather than bring in a person to study their own topic. And as a result of that effort, we brought in 3 Edison Research Fellows who've been studying topics related to patent litigation. Jonas Anderson, who worked on classifying and evaluating patent claim terms. Joseph Bailey, whose project involves refining prior art search through machine reading. And Deepak Hegde, who's been looking at patent quality metrics. And I should also note that meanwhile, we've continued to operate our original Edison Scholars Program as well. We brought in for the first time someone to look at a trademark issue, and that was Graham Dinwoody, who's looking at whether trademarks define rights based against existing usage or rights to economic expansion beyond existing usage. And Josh Sarnoff, who's been looking at patent claims analysis and continuation practice. So today we will hear from several of these illustrious academics whose names I've just mentioned. So we'll hear from Joseph Bailey, Josh Sarnoff, and Deepak Hegde. So just to say, overall, obviously, we have become a very active proponent of evidence-based policymaking, trying to do some of it in-house and some of it through outreach to academic experts. We are involved in looking at and doing evidence-based policymaking every day. We very much value the contribution of academics, and we're very interested in the broader discussion of how their contributions can best be made in a way that helps inform policy. So let me stop there and turn it over to the panel. Thank you.
Hi, my name is Tim Simcoe. I'm here from the Council of Economic Advisors, although I'm usually a professor at Boston University. So I'd like to just begin by thanking the PTO and Hoover for the invitation to moderate this panel. I think the purpose of the panel today is to just give this crop of Edison scholars a chance to discuss and highlight some of the research that they've been doing. So the format is I'll say a little bit about each of these three scholars and then give them each around 15 minutes to present their work. I'd ask you to hold questions unless you have a burning question of the clarifying nature. And that'll hopefully give us 15 or 20 minutes to do audience question and answer. So let me say a bit about each of these three researchers. So Joe Bailey, the gentleman immediately to my left with the outstanding patriotic bow tie, is a faculty member at the University of Maryland. His research focuses at the intersection of information technology and business, and he directs a grad program that spans engineering, science, and business. Joe has a PhD from MIT in the Technology Management and Policy program, a master's in engineering economic systems from Stanford, and a bachelor's in engineering from Carnegie Mellon. In the middle is Deepak Hegde. Deepak is an assistant professor at NYU's Stern School of Business. His research on innovation, intellectual property rights, and entrepreneurship has been published in journals such as Science, Nature Biotechnology, Management Science, and the Journal of Law and Economics. He has a master's in public policy from Georgia Tech and a PhD in business administration from UC Berkeley. And at the far end of the table is Josh Sarnoff, who is a professor of law at DePaul University College of Law. Joshua teaches patent law, administrative law and climate change. His research focuses on patent eligibility, claiming doctrines, and other patent law issues. Professor Sarnoff is also a registered patent attorney and a former member of the Board of Governors and the Federal Circuit Bar Association and the Board of Managers of the Intellectual Property Law Association of Chicago. So I look forward to hearing about the research that these three have all been doing as Edison scholars during their time at the PTO. And first up, I believe, is Joe.
So thank you very much, Tim, and thank you all for being here today. As an alumnus of Stanford, it's nice to be kind of a little bit on campus, even here on the East Coast. It's also nice because as I've spent time with the Office of the Chief Economist, the Stanford people seem to be outnumbered by the Berkeley people, so it's particularly nice to be here at Stanford to talk about these issues. But thank you to Hoover for having us, and thank you to the PTO really for running this program. As somebody who, before I started as an Edison scholar, I spent 9 years as an expert witness on patent litigation. I think it was really neat to go ahead and kind of give that up and take a look about how the PTO operates and to understand things like office actions and what examiners are thinking from the inside out, as opposed to just looking at file wrappers of patents and thinking about their validity, invalidity, or infringing or non-infringing technologies. So my research is particularly keen on trying to understand how examiners and how the PTO can look at the growing corpus of prior art and think about the ways in which the best prior art can be put in front of examiners so that they can better do their job. So this chart over here is probably one that you're familiar with. We talk about the accelerating pace of innovation. And what I have is on the blue line is the growing number of patents ever since patent number 1 was issued back in 1836. And as you may know, the PTO had a bit of a milestone a few months ago with patent number 9 million being issued. And if we take a look at the growth of it, it's perhaps remarkable, maybe not so much to this audience, but patent number 2 million was granted in 1936, so it was 100 years between patent number 1 and patent number 2 million. Well, we've gone from patent number 7 million to 9 million in just 10 years. So again, what used to take 100 years now has taken 10 years, and one can only imagine if we extrapolate this, how many more patents will be issued and granted, and then of course how many examiners are necessary to go ahead and keep up. As you notice, the red line there doesn't exactly track well initially, but it's keep catching up a little bit now in terms of making sure that we have the right number of examiners to carry the heavy burden of looking at so many applications coming in. But of course, the job of an examiner for patent number, let's say 9,000,001, is a little different than the job for number 2, because there's so much more that an examiner has to do when considering prior art and understanding exactly how the claims of a patent will go ahead and distinguish it from the prior art that is there. So again, my research is to figure out ways, and specifically an algorithm or set of algorithms that can be used so that we can better mine this growing corpus of documents. And then, of course, how the PTO can make sure that this algorithm is not just good enough for today, but how the algorithm can grow and learn from examiner activity, hence the learning part of machine learning. So if we go back on the left-hand side of the picture about the paper age, this is actually a picture of what they call the shoes. And one could remember perhaps reading or hearing about them. But the idea is that at one point we had physical documents that examiners needed to consider. And believe it or not, there were some benefits of having a physical document that an examiner needed to consider, including the fact when you opened up the drawer and found that what you were looking for was missing, that meant somebody had it, and now you had to enter into a conversation with somebody about that document, which may actually help you if you were trying to learn what is inside that document or how it may help you understand a particular docket item that you have. As we move away from this, clearly this is not a very scalable technology, and we think about databases. The PTO has very sophisticated databases to help manage lots of prior art documents, both patent literature and non-patent literature, and making sure that examiners have the best possible tools for them to search this is important. And one of the things that we learn about what the PTO is doing in the digital age is as applicants are their own lexicographers, examiners have kind of become their own thesaurus. In other words, an examiner, when searching, knows not only what to search, but what other terms to search in order to find relevant literature. And then, of course, the question is, if we move from this digital age to potentially an intelligence age, can we actually imagine algorithms working on behalf of examiners doing what they do, or potentially finding ways in which we can go ahead and modify or maybe even put into practice algorithms which take in consideration the best practices among this 8,600 size examining patent corps. So the research question about how can machine learning be used to help uncover prior art was where I started. And in order to really benefit from the fact that I was at the PTO, I've benefited tremendously by many people in the room and many people back in Alexandria at the PTO. But Jamie Kukab, who's sitting there, who is a former detailee with the Office of the Chief Economist, was very instrumental in me not only understanding the examiner perspective, but actually helping me build the algorithms and talk to examiners. In fact, here's a picture of Jamie and I with a few of the examiners that we worked with over the past 8 months. We were able to get the PTO's support and the POPA, the union's approval to go ahead and work with some examiners across 3 different technology centers at the PTO to understand what types of algorithms are currently available, both internally as well as externally to the PTO, and ways in which our own prototypes can be improved upon based upon their feedback. So thank you to Jamie and all the other examiners at the PTO. Again, just an example of how being an Edison Scholar gets you insight and access to things that you would not from the outside. So let me go through and just walk through a few different elements of the algorithm as it exists today, and I'm happy to take questions later about this. But The first thing is, here is a set of some of the search strings that are used by examiner for an example search. And what an examiner here is basically doing is truncating words, or what we call stemming words, to go ahead and find words of various varieties for plurality or singularity, as well as different suffixes, but also for synonyms as well. And you could see that the searches has gone through from 1 through search 4, going from everything from over 500,000 hits down to about 1,000 hits. And one can imagine how easy or difficult it is to go ahead and even go through the 1,000 documents that are there. Again, this is the proverbial needle in a haystack type of problem that an examiner faces. And so the question is, well, what happens if the best reference was somehow left out as you're taking the intersection of these first 3 searches? Or even how do you look at the 1,000 search results that are still left after kind of taking the intersection across these 3 searches? And I think the first part of the algorithm that I want to share with you is, well, by saving the search string transaction history, that the words within specifications and claims of applications can then be stemmed and lemmatized based upon what examiners are doing. In other words, if we're going to go ahead and mark up documents, whether it's the corpus of prior art documents or it's the applications that come in, we can actually use the own way in which examiners have built up these thesauri to go ahead and do that. So the next part of the algorithm is that there's a nested thesaurus. And so again, think about this as following the classification system, where basically words have meaning within a particular context, and that meaning might be different in other contexts, or potentially they have multiple meanings as you move across the context. So in this way, what Jamie and I have built is a nested thesaurus, whereby documents are marked up based upon the instances of words and bigrams, either within a global thesaurus level, within a class level, and then ultimately to a subclass level. And then by marking up these documents, that we can then compare how similar or dissimilar documents are based upon the instances of the words and bigrams. So the third part is actually then the text mining. So on the left-hand side, we see a claim. On the right-hand side, we see kind of a set of patents, which are in the prior art. And for what Jamie and I built out, our corpus involves about 400,000 patent granted documents between 2005 and 2014. And the idea is that by looking at the use of the words and the number of instances of the words and bigrams, that we can apply these thesauri, compare the results by looking at this, and then filter the results to the nearest neighbor. Again, we can think about this as an n-dimensional problem whereby the prior art is either far away or close, and the question is what constitutes how far or how near something is. And perhaps it's easiest to think about it in this way, where one can imagine kind of a scatter plot showing some of the nearest neighbors. Now this particular one is demonstrative of the fourth part of the algorithm, which is the fact that we have kind of green, red, and blue dots. And if what we're doing is comparing this kind of star, that's our application, we're trying to figure out where the results come into play. And ultimately, what Jamie and I realized was that we don't necessarily want to present examiners with all the best results, but we actually want to provide them a distribution of results that come from different clusters. In other words, it's not just the best to go ahead and say, here are all the blue dots that score the highest. Here are some blue dots that score the highest, but here are also some red and green dots that you might want to consider as well. And that not only helps improve the learning subsequently, but realizes then that examiners have the opportunity to examine some of these documents and then look for subsequent related documents. The next part of this is where the supervised learning comes into play, which is when the results are then either used or not used within the office actions by examiners themselves. So Jamie spent a lot of time actually looking at the references that are cited in office actions from a handful of cases, and the notion is that we can update the weights on the instances of the bigrams and the words within the nested thesauri to go ahead and basically say what words or bigrams are more important than others when using kind of a logistic regression model to predict the use of a reference in an office action. So that's really the algorithm in a nutshell. There was another effort that Jamie really spearheaded, which looked at actually developing a prototype for what an interface may look like for an internal tool for examiners. Jamie will be available if you want to ask him more about this. But the basic idea was we want to make sure that the algorithm could be used in combination with other algorithms. In other words, we can take internal tools, we can take external tools, and we could basically think about unions and intersections of the algorithmic results on a common interface. So there's significance across a few different kind of areas of the PTO. So one thing is the algorithms can certainly help us and hopefully help examiners, again, not replace examiners, but aid them. Taking a look at ways in which new terms are being introduced within different areas. Thinking about the way classification and potential reclassification can be used based upon how tight or how distributed different documents are. And the last one here is the one I want to touch on briefly because the Patent Office held a quality summit back in March. And one of the proposals that came out of this was that the PTO is investigating the use of a pre-examination search. And the thought is that some algorithm or combinations of algorithms would be used to send prior art back to an examiner after an application has been filed. So I tried to distill this in what one might expect in a kind of a text exchange between the PTO and an applicant. On the left-hand side is the current state, and on the right-hand side is what a potential pre-examination search state might look like. The green bubbles are automatically generated, and the blue ones are generated by an examiner. And the key here is that there is this period of time after an applicant has filed an application, but before the examiners had a chance to pick it up, where an automated pre-examination search might produce some prior art, and the applicant could then choose or not choose to comment on that prior art. And if they so choose to do it, they could reduce the number of iterations necessary to go from an application potentially to a granted patent, because the applicant would have an opportunity to comment on some prior art that would be put eventually in front of an examiner. So thank you very much for your time. I look forward to their discussions afterward.
Okay. Very good afternoon to you all. Thanks a lot to Hoover for the opportunity and to Tim for agreeing to moderate the panel. I think pretty much if there's one point that everyone in this room can potentially agree on, it is that the intended function of the patent system is to promote innovation, okay? And the idea is that by giving limited term rights to inventors to make, use, and sell their inventions, you're getting them to invest in innovation. And there is some academic research which suggests that patents do perform their intended function, both by inducing investments in innovation, but also by getting inventors, particularly small inventors, to specialize in the job of innovation such that they can then take the patents and then sell it to other parties who are willing to pay a price to develop them. Okay? However, if one looks at the coverage of the patent system in the media, particularly recent coverage, what you see is headlines like this. Google says patents killing innovation, patents that kill. Here's why patents are innovation's worst enemy. How patents kill innovation and hold tech companies back. The latest threat to 3D printing, stupid broad patents. Okay? So it's easy to walk away with the impression that the patent system overall might be harming rather than helping innovation. Okay? And what is common to most of these articles is that they seem to point to the growing incidence of litigation, patent litigation in the United States. So here's basically compound annual growth rates for patent litigations compared against the growth in patents starting from 1991. And you do see that patent litigation seems to have grown at a slightly higher rate than the number of patents themselves. Okay? And experts who have looked at these litigation rates, at least some of them, have laid the blame at least partly on the US patent examination system. And the concerns have been expressed differently, but it seems like the Patent Office in particular is getting a blame for giving away too many patents, giving away patents that are too broad, and taking too long to do it. Okay, so here's basically a summary of what the experts are claiming. The problem of patent trolls is a function of the promiscuity with which the Patent Office has issued patents, and so on and so forth. Okay, so the objective of my research has been then to take a look at data and establish some systematic facts about the performance of the US patent examination system. Okay? In particular, we break down our examination of data into matrices that correspond to three aspects of performance of the Patent Office. The first relates to quality and answers the question, how lenient is the Patent Office in granting patents that it receives? Okay, and again, many of the experts have suggested that the Patent Office allocates nearly every a patent to nearly every application that it receives. Okay, and the second question that we are trying to look at is, how long does the Patent Office take in making its final decisions? And third, to the extent that we see variation across years in the time taken by the Patent Office, as well as the probability that it grants a patent, how much of it can be actually ascribed to changing standards of patent examination at the Patent Office? These are the three questions that we kind of try to establish systematic facts about. Okay, and to be clear, when we talk about quality, we do not think of an optimal quality or an optimal speed. The only thing I can say for certain is that, especially with regards to quality and how that relates to the probability of granting a patent, ideally the ideal optimal grant rate lies somewhere between 0 and 100%. And it entirely depends on the nature of the applications that come in. That's the only thing that I can say with relative certainty. But what we do in this exercise then, therefore, is to only look at changing trends in these different matrices in the last 20, 25 years or so, and then derive implications to what we might think about the changing nature of the examination processes. Okay, so here's a simplified diagram of the patent examination process. What we did was we looked at 2.15 million patent applications filed between 1996 and 2005 at the Patent Office and disposed of by the end of the year 2012. And what we found was that basically only 11.4% of the applications that were filed at the Patent Office between these years were granted after first office action. Okay? And eventually only about 55%, 55.8% to be precise, of the applications were eventually issued as patents. And then accounting for the procedure of continuations, the process by which some applications give rise to children and relatives and so on, even after taking that into account, only about 71.2% of all the applications filed at the Patent Office emerged as patents. Okay? So having found this, what we also then found was that while those were the average figures for the entire span of our study from 1995 through 2005, what we see is substantial variation in patent allowance rates across time. In particular, it seems like patent allowance rates go up to a high of about 80% in 1998 and have declined ever since to somewhere around 45%, 40 to 45% by 2010, and seem to be creeping back up again. Okay, and then the question then is, to what extent is this variation a function of the changing standards of examination at the Patent Office? We wanted to take a look at that. Okay, and correspondingly, thinking about the timeliness or the speed at which the Patent Office prosecutes applications, it seemed like the declining allowance rates at the Patent Office coincided with increasing pendency at the Patent Office. So between the years 2000 and 2009 in particular, you see a sharp increase in the amount of time taken by the Patent Office to issue their terminal actions. Okay? So the idea was then to look at variation both in the time taken by the Patent Office as well as in the rate at which it grants applications as patents, and explain them as a function of different aspects that we get to see and measure, including characteristics of the application, characteristics of the environment that the Patent Office operates in, including macroeconomic conditions, potential fluctuations owing to seasonality, as well as calendar year effects. Okay, and here's a smaller technical point, which is that modeling this econometrically is tough, primarily because A, we are looking at two outcomes. One is the probability of allowance, and the second is the probability of abandonment or rejections, which go hand in hand. The two are clearly related, but factors that drive the two may have a differential impact on the two differently, and therefore we need to propose what is called a competing risk survival model. The competing risks are the risks of abandonment and the risks of the patent office allowing patents. And each of them, we allow each of the covariates to have different influences on the two outcomes. And what we did to sort of reduce our computational burden is work with smaller samples of the data pulled out between 1992 and 2012. And some of the models that we have sort of take care of some of the standard issues that come up, including the ones of censoring. Okay, and basically what we find is that there are several factors that we can observe and measure that have a significant impact on both the delays at the patent office as well as the probability that an application emerges as a patent. And most of these factors seem to be inversely related in terms of their influence on the two outcomes. So most of the factors that seem to depress allowance rates also seem to increase the time taken by the patent office to issue their final decisions. So if you take, for example, the proportion of senior examiners at the patent office, it seems like as you allocate more senior examiners at the patent office to examining the applications, patent allowance rates go up, but patent pendency rates go down. Okay? The same thing happens to the number of the stock of pending applications at the patent office. As the patent office is faced with a larger burden, the dominant impact of the larger burden at the patent office is to increase pendency times, but also decrease allowance rates. Okay? So, however, there are some factors that seem to work together in terms of lowering allowance rates and also decreasing examination delay. For example, applications filed by small entities are more likely to have a terminal decision much more quickly, but also small entities have a lower rate of allowance at the patent office. Again, it's not causal. One of the reasons we found was that the smaller entities, as you delay the patent examination process, are more likely to abandon their application, presumably because uncertainties about the quality of their or the value of a patent resolved for them, and they voluntarily chose to abandon their applications. Okay? And then there are some factors that increase examination delays but also have higher allowance rates. For example, the number of claims in a patent. Okay? It seems like both delays, both abandonments as well as grants, but also increases the probability of allowance. Okay? So what we eventually kind of wanted to look at was, to what extent can the changing allowance rates at the patent office be explained by these characteristics or covariates that the patent office has no control over? Okay? And it seemed like about 70% of the variance that you see in these allowance rates can be explained primarily by the environmental factors that a patent office faces that the patent office does not have much of a control over. And about 10% of the variance is explained by what are called unobserved effects, part of which could be changing examination standards at the patent office. So even to the extent that we are not able to isolate and identify the effect of changing patent standards at the examination office alone, it does not seem to have a substantial effect on the allowance rates that we see and that we are able to model and predict. Okay, and then what we started looking at was trying to see whether the quality of the output of the patent office has changed over time. And we tried to find two measures of the quality of the patent examination at the USPTO. And in some sense, the notion of quality that we adopt is that if an examiner at the patent office makes a decision, if that decision is subject to greater scrutiny at a second round, what is the probability that the second round of scrutiny upholds the decisions of the patent office? If there is 100% correspondence between the second layer of scrutiny and what the patent office has done, then that, we argue, is correlated with lower errors. And so what we do here is take a look at two errors. One is what are called type 1 errors, which is basically for the set of patents that are granted, how many that are selectively taken to the courts and eventually are ruled on by the courts, what proportion of them are invalidated, okay? And equally type 2 errors, which is the applications that are rejected by the patent examiners, to what extent, if they are taken to the BPAI and now the PTAB, are reversed by the second layer of scrutiny that happens at the formerly BPAI and the current PTAB. And what you see here is that, in fact, these two measures of errors, in fact, seem to be going down or more or less flat with time, both type 1 and type 2 errors. Okay? So to the extent that you believe that this is a measure of quality, it seems like clearly that there is not a huge change in the quality of the examination that is going on at the Patent Office, at least since the year 1993. Okay? So overall, then, what we find is that the data reveals significant declines in patent grant rates, especially after 2000, with a small and minor uptick after 2009, 2010. And it seems like the changes in grant rates are largely explained by changes in economic conditions, the nature of applications that are filed at the Patent Office, the nature of applicants, as well as pendency at the Patent Office of unexamined applications. Okay, and examination delays seem to have increased after 2000, which seems to correspond with lower observed allowance rates after the year 2000. And the one thing that we find here that may strike some of us as counterintuitive is that increasing delays at the Patent Office is not necessarily bad. And the reason why it is not necessarily bad is that it gives time for the applicants themselves to figure out whether their patent is worth investing in. And many patentees, in fact, abandon their applications, and the proportion goes up as you increase pendency at the Patent Office. And so that could be one potential benefit of delays at the Patent Office. Okay, in general, to the extent that examination errors, both type 1 and type 2, can be argued to be a measure of quality, there seems to be no evidence that examination errors have increased in recent years. So what do we take from this work that can be used to take it to the policymakers and think of potential levers that we can pull to improve our patent system? At least for starters, it seems that the calls for patent reform, to the extent that they are uniquely based on anecdotes of silly or trivial patents, and are therefore then used to infer that that examination quality has gone down, does not seem to be substantiated by the data. Okay, the one thing that is worth noting is that litigation is driven by both the value of property rights as well as the contestability of property rights. Okay, so increasing litigation might in fact be because of the increasing value of property rights. And certainly we do not find evidence, at least here, that it is driven by increasing contestability of property rights, at least judging by the lenience of the Patent Office as well as the error rates that come out of the patents at the Patent Office. Okay? And also that if the Patent Office is working with limited resources and has to allocate it either for speeding up patent the examination process or reducing errors, then it is worth considering that an unintended or unforeseen benefit of delaying examination might be actually that it helps applicants self-select the patents that they want to pursue. In ongoing research, what I'm trying to do is take a look at some of the internal management practices that pertain to the quality of examination at the Patent Office in the past and how they may have affected the error rates of examination. Also look at the role of patent publication in reducing R&D duplication, and then understand whether patents as property rights are indeed helping entrepreneurs raise capital and eventually take their innovations to the market. All these separate studies that I'll be happy to talk about offline. So thank you.
So I'm Josh Sarnoff, and I'm really delighted. Thanks. To be here. Thanks to Hoover and to Tim for moderating. My real thanks to the PTO for having me as an Edison Scholar. I tend to do doctrinal patent work. This has given me the opportunity to actually do empirical work. So some thanks are due to the efforts of various people to both help me understand the data that we're dealing with as well as to work with it. Obviously, my co-authors, Alan Marco and Charlie DeGrazia, Joe and Jamie, who've been mentioned, Bob Kimball and Jesse Frumpkin, who are also working on some of the project, and of course to Shira and George for supervising me, keeping me out of trouble. The work that I've been trying to do started with some questions. As I say, you know, as has been mentioned, I've been interested in claim scope and interpretation issues for a long time, but the question is really what happens to patents and patent scope during prosecution. To my knowledge, this is the first set of studies that actually look at how patent claims actually change during prosecution on a statistical basis. And the question, of course, is how does the scope and clarity change and what can we learn from it? There are some general relationships that we're hoping to establish, both between the way that things change and certain characteristics of prosecution, including pendency, which Deepak just talked about. There are, of course, some data limitations. In particular, we can only observe the claims from the data sets at two stages. The first is at publication of the patents applications, and the second is at the grant of the patents. This restricts our data set a lot. We also make what we think is the reasonable assumption that the patents claims at publication look a lot like the patents claims at the application stage. And in the subsequent work that we're going to be doing, we're going to be looking at a number of additional prosecution characteristics, such as RCES and continuations. The data set is quite large, and again, this is, I think, one of the real efforts both of the office and of the Edison Scholars Project, that we can get all of this data out to the public for analysis, and obviously we can do it. Some of that analysis in-house. What I'm going to be talking about are mostly summary statistics rather than regressions. What we have are two data sets. One data set contains the full text for each claim that was published between 2001 and 2013, and we have a set of the full text for each claim at the grant stage from all the way back to 1976. So we're talking tens of millions of claims being analyzed. And again, that helps with the analysis in terms of its statistical validity. We're looking at principally two indicators that we try to correlate to claim scope. The first is the minimum independent claim length, although we also test for average independent claim length, and the independent claim count. There are some assumptions behind those, and the basic assumption is that the more words you add to the claim, the more it should narrow the scope. And therefore, measuring the minimum independent claim and how that minimum independent claim length changes is a measure of how much claim scope changes during prosecution. Similarly, if you assume that independent claims are supposed to be not redundant, then the more independent claims you have, the broader the scope of the application in theory should be. So we measure the minimum independent claim lengths at those two stages. We measure the independent claim counts, and then we do analyses, mostly trends analyses and some measurements that we will be doing regressions on. And we do this often by subgroupings to try to look at various characteristics, such as did things change for particular technologies? Does it change for particular parent types? We also match this against certain measures of pendency. We look at time from first office action on the merits to the final. What I'll be focusing on is total pendency here. So what do we see? Some of the data, when it says publication, we have two things that we can observe. We actually distinguish between at publications, applications that will result in issued patents, those are the ones in green, and applications that will ultimately go abandoned. So that's why you'd see these two sets. What we measure is, on the bottom axis, the number of words in the smallest independent claim by word count. And we're measuring the density of claims that have that amount of words. So those are percentages of their group. What's most interesting about this particular graph is that the claims that go abandoned after publication tend to have more claims that have fewer words. This suggests that broader claims, fewer words, are less likely to get granted. Not a surprise, but it's statistically proven here that this is what is in fact happening. When you then look at the change length to grant, what you're seeing here in green was the green from the slide before. Those were the claims at publication for those claims that will ultimately get issued, for those applications that will ultimately get issued. And what you can see is that as you go from application to grant, you're adding words. The whole distribution gets pushed out. So this suggests, again, that what's happening during prosecution, which again really shouldn't be quite a surprise, is that claim length gets increased, claim scope gets narrowed, the patent claims therefore get allowed. One of the things that's interesting is that that tail of very small claims gets eliminated in the grant distribution. We're not quite sure yet what to make of that. When you go to claim counts at publication, rather than claim lengths at publication, we see an interesting phenomenon. Here, the claims for applications that ultimately go abandoned tend to have a larger density of fewer, particularly one independent claim, more than the ones that ultimately get issued. There's two potential explanations for this interesting phenomenon, because if you think about it, if you have more single claims, that's supposed to be narrower scope than if you have multiple independent claims. One possibility is just that where you have fewer independent claims, you're just less, or broader claims, you're just less likely to file additional independent claims. Another possibility is that, at least for the category of single claims, if that one gets knocked out, you go abandon, whereas if you had two claims, you stay within the issued patent claim group, and maybe it's just a function of the numbers that those drop out. Again, though, what we do see is when you move from the claims at publication to the claims at grant for those that will result in issued patents, you see a higher density of the single independent claims at grant, right? So again, it says that they're dropping claims, independent claims, narrowing scope as you go forward, which again shouldn't be a surprise. It unfortunately doesn't tell us very much, though, about continuation practice, whether those independent claims that got dropped continue to get prosecuted. Okay, we've, as I said, broken this down by various categories. You see essentially the same change from publication to grant, where this claim length gets pushed out to the right. You get longer claims, therefore, in theory, narrower scope. The only thing I think that's particularly interesting about these graphs are for chemical and drugs and medical. You actually have many more shorter claims. This is explained in part by the fact that in those particular technologies, they often claim single chemicals, which tend to have fewer words in the claim. Similarly, when we look at the claim counts, you see the same decrease in the number of claims when you move from publication to grant. So these are, again, not surprising results, but there are, again, differences between the particular technology sectors in terms of how much those effects matter. We also took a look at parent types, what the parent of the application we're looking at looked like, where there was a priority claim in the application. And the none is the set of claims that come in without any priority claim to earlier applications. Again, you see the same general phenomenon. All of the at-grant claim lengths are shifted out in the distributions. So again, we see for pretty much every set, although again at differential levels, that you're adding more words at grant, and therefore, in theory, narrowing scope as you go through prosecution. Again, same thing for claim count, where you're dropping independent claims. Again, you see some interesting differences in the shape of the curves, particularly for the divisionals and PCT-US sectors. We also looked at another set of factors, and this is the differences in claim lengths as you move through the process and map the distributions. As one would expect, the highest frequency is around 0. Most of the highest number of patents in the samples actually don't change their claim length at all as they go through the process. But as one would expect, there are more claims to which you add words and narrow the scope than there are claims where you decrease the words and, in theory, broaden the scope. Similarly, for claim counts, you tend to see it left skewed, where you've got more claims, obviously, that don't change, but more claims tend to lose independent claims, sorry, more applications tend to lose independent claims than gain them over the course of application. We also took a quick look at the difference in claim length by entity status. It's very hard to see on these curves. 0 reflects that this is not a small entity, 1 that it is a small entity. They tend to have the same shape, but it turns out that small entities tend to add more words to the claims as they go through prosecution, which suggests that small entities at least might be filing more overbroad initial claims than larger entities. Perhaps that's a function of better lawyering. Who knows what the actual causes are. And this, again, the same thing with claim count. It's hard to see, but it's actually the small entities drop more independent claims. As I said, we also took a look at minimum claim length and pendency. And the important thing on these scatter plots is the diminishing line. What you see there is that there is a trend, and the trend is that there are more words at, the fewer words that you have at publication, and therefore the more words that you end up adding, so this is a difference plot, the longer it takes to get through prosecution. That's on the next one, is the change goes up, the more words you have to add, and here the fewer words, the broader scope you start with initially, the longer it takes to go through prosecution. Again, this makes intuitive sense. If you start with broader claims, you're more likely to have a difficult time in prosecution, demonstrating that you're entitled to that full scope. And again, that shows because the more words you have to add to get to a scope that ultimately gets allowed, the longer it takes you in prosecution. Finally, 2 things that I'll mention about our regression analyses. We looked at the changes to the number of words in the claim and measured against the number of RCEs that are filed on any particular application. And it should not be a surprise that for each round of an RCE, there is a certain amount, somewhere between 20 to 30 words that are added on average to each claim. This makes some sense, and at least initially suggests that RCE practice is doing what it's supposed to do, which is allowing people to continue to prosecute in the same application to reach an appropriate scope. Similarly, we looked at claim counts and continuations, and the claim counts go down. And they don't change very much in terms of claim length with continuations, but you do see a reduction of about 0.5 independent claims each round of continuations that you go through. And again, that makes some sense. It doesn't answer the ultimate question, of course, whether or not what ultimately gets issued is valid, but it does suggest that, contrary to some assertions, that continuation practice just allows the same claims to get out through multiple rounds is not what is actually occurring in the data set. So There's a lot more that we need to do. The best thing, of course, is by publishing the data sets and some of our summary analysis, we can spark others to look at the evidence and play with it themselves. We're going to be running further regressions, and hopefully we will be able to match against some validity indicators and other prosecution quality concerns, at which point we may have some more robust recommendations in terms of how one might think about matching quality and clarity of the record and scope concerns with the actual practices of lawyers who file the applications and examiners who have to review them. Thanks.
Okay, so I see two people standing in the back of the room with microphones in their hands, which preempts the question I had for our hosts about audiences seeking a microphone before they ask a question. So if you have questions, raise your hand. I will try to keep a list, and I'm sure you'll get the attention of the two young people in the back with the microphones. Before we start, I'm going to use the moderator's prerogative to sort of put the first question to all three of the panelists. But I'd like to start with just the observation that this sort of collaboration is not easy, and these folks in the PTO deserve a great deal of credit for moving the ball forward in terms of doing empirically grounded, policy-relevant research using administrative data inside a government agency. That sort of stuff really is a great example of two things that I've learned during my year here in DC are big priorities of the current administration. One is sort of making open data the default. You know, I think this is something that the Office of the Chief Economist at PTO under both Alan and his predecessor Stu Graham deserve a great deal of credit for. They've been leaders in this regard. And I think it has a lot of potential as we sort of continue to work on this patent quality initiative that was mentioned earlier. And then secondly, you know, sort of this is the other administration priority is just evidence-based policy making, which is really the theme of the day. And so that leads to my first question for these folks, which is really just to ask you to reflect on what you've learned in the process of collaborating with the PTO. Maybe you could say something about areas or ways to improve the collaborative process or areas for future research, new data sets or links that would inform really impactful follow-on studies or challenges and opportunities for translating this stuff into better public policy. But, sort of, do you have reflections on the process of trying to generate empirically, policy-relevant empirical insights for intellectual property policy? We can go. We'll do the same order as the presentations unless you guys want to jump in.
That's fine. So I think the one thing that I learned is there are many sources of data, but they don't always reside in the same place or talk to each other. So in the spirit of mashing up data sources, finding out the people within the PTO who have stewardship over those resources and making sure that they can be shared and it's consistent with their mission. That's I think an important thing, and I think scholars are using the data in new and different ways, and I know Alan works very tirelessly in trying to make it more easily accessible, but I just think the ability to kind of cut across some of the institutional divides within the PTO, making the data a little bit more accessible. And so I know in my own efforts, getting people to think about ways to create APIs in order to access the data and then being able to make multiple calls to APIs across different parts of the agency, but using things like similar tokens so that way when people are mashing up different data sources to kind of measure that latent demand for data.
So just reflecting generally about my experiences with the Patent Office, and hopefully this will encourage other scholars to also actively engage with the Patent Office, is that, the one way it's been very beneficial is there are many people who work with patents, both as indicators of innovation as well as thinking about patents as a way of inducing innovation. And working at the Patent Office gives you such a great opportunity to know how the data are actually generated that can enrich research on patents, whether they're used as indicators of innovation or as systems that induce innovation in a way that is impossible from the outside. So very broadly, I think that is a huge plus. Having the leadership at the patent office and including at the chief economist's office that encourages research without worrying too much about the bottom lines, what the outcomes of the research are going to be, is something that as academics we value a lot and is absolutely being protected, at least currently, and that's been a great experience. Now, in terms of where the patent office might itself potentially benefit more from interacting with academics, I have the sense that the way we can add the most value, particularly uniquely by working and spending time at the patent office, is by scrutinizing the procedures at the patent office itself and examine how that may have a bearing on the quality of the output of the patent office. And I know many of us academics, at least economists, like to think about randomization. I don't think we need to go that far. There are many things that we can think of as little experiments in terms of changes in management practices and so on at the patent office that have happened in the past, that the patent office, I think, will benefit immensely by looking at what their outcomes have been for the larger outcomes we care about, which is patent quality and their effect on promoting innovation. And I would urge the patent office to enlist academic research even more than it currently is in this regard. Briefly, I would like to end by echoing Shira's words that overall the experience is one that completely changes the way you think about research and issues related to patents, the experience that you just cannot gain otherwise, that I would encourage others to benefit from.
So one of the big problems is having the right data to analyze. And one of the data limitations we had, for example, in what we were doing is that, when you're talking about decades of examiners in the process, we haven't historically coded all of the changes from one claim that happened through the process. So we're using measures that are proxies for this claim, the minimum independent claim at public and the minimum independent claim at grant, but we don't know if they were related to each other directly. So it costs a lot of money and time to actually think about what are the future needs and how do we collect a whole bunch more data that could be useful. So I would encourage greater investment in the types of data generation and data collection that could be of use for the future. That's a costly endeavor. The good news is some of this can be overcome precisely through the type of collaboration across disciplines that you're talking about. So I mentioned Jesse has come in and he's giving us other ways other than just claim count to try to measure breadth of changes, and Joe was also very helpful in suggesting things about how we could actually measure from publication to grant and how things changed. Those types of collaborations can only happen when people are in proximity talking to each other. So again, I would just encourage more investment in collecting the data, more investment in bringing people together. The other unintended benefit, of course, is I just haven't had this much fun in a long time. So, it's a great thing from our perspective, but it does cost money, and I just would encourage increasing the amount of money and people who can get involved, and particularly collecting the right kind of data, which is often asking people to do more when they're already burdened. I mean, if you think about the examiner's job, it's difficult. If they now have to code these things, that's going to be asking for things. Those are difficult discussions to have.
Okay, so I promised these guys I would ask a softball first, but I'm counting on all of you to ask pointed questions about their research. Sure, we should start with you pick.
Start with you. Thank you. So I'm wondering, so I'm struck, first a reflection and then a question. So I'm struck, in fact, that the USPTO has only recently begun a program of bringing academics in, and I think it's great that they have. But what's striking to me is how recent an innovation this is when you would compare it to entities like the Federal Reserve, which have had academics in residence for decades. Which sort of again gets me to a question, which is based on what you've sort of learned as Edison scholars, what is your sort of sense of the overall state of the academic literature about the patent system?
So I'll address that, I think, by just making the observation that there's incredible talent at the patent and the trademark office, right? The PTO's got really, really smart people. And I know in working with examiners, I mean, they're simultaneously, technical experts in whatever their art area is, but many of them really have legal scholarship that's fantastic as well. So in terms of being an environment that's ripe for doing research, there's incredible, academic scholarship, intelligence, an understanding about kind of what the literature is. I think what perhaps hasn't happened until recently is they've been consumers of knowledge as opposed to creators of knowledge, or if you will, enablers for other people to create, or understanding how important that part of the mission is. And I think that's what's changed.
I'll just take a quick statement. For years in the academic literature, you've had fairly good doctrinal scholarship. With the change to the law and economics movement, you started to have a beginning of a penetration of empirical methods. That's, I think, increasing significantly. I think that there's still a tremendous clamor for more empirical analysis that can answer the hard policy questions, and it's really hard to do. So again, part of the reason it's hard to do is the data isn't collected, and that requires political decisions by the institutions. I mean, you think about the court system, they could collect a lot more data on all of the filings that come in, but it costs a lot of money. If the political will gets there, then I think you'll see a even greater explosion of the amount of empirical analysis that would be helpful on policy issues, but it requires getting the data.
I'll offer a quick observation on that one too, since it sounded like an invitation to pick on the literature. In any place where there's low, where the costs of data access are low, you see a lot of scholarship. A lot of it won't be great, and some of it will be fantastic. When I think about the big questions here, I would sort of offer the following observation, at least as applied to the economics literature. We've had a lot of studies over the last maybe 2 decades that have looked at existing patents changing the institutional regime where they live. Basically, sort of it goes from valid to invalid, or we're going to charge a price to free, and studying sort of effects on cumulative innovation. And sort of basically showing that the derived demand, like the input demand slopes down. Like when it becomes more available, it's more likely to get built on. That's a useful result. We have much less knowledge about the upfront incentives. If you think about what does the existence of the patent system and the way it's designed actually do to stimulate sort of the first invention in the chain, and but the other way to think about it, I guess, is, but for the patent, how much of this innovation would we have gotten? It's a really hard question. I don't think, I think it's tough, and it's going to continue to be tough, given, even if all of the data wishes sitting up here are kind of granted.
For you, and without getting too much into the weeds on answering this question, you said the litigation was driven by the value of the property and the contestability. And I guess ex ante, how do you know, how did you measure that in doing your research?
No. So what was underlying that statement was more a mental model based on value of litigating, right? I mean, a party might think of litigating a patent, and that thought might be influenced by expected benefits from engaging in litigation. Expected benefits, in turn, is a product of the value that you will get from the litigation and the chances that you will win the litigation suit if you enter into it, and then the cost of the litigation itself. What I was suggesting was that when you see an increase in litigation rates, it could be driven by any of these factors, okay? Now, what we are able to do by looking at the type 1 versus type 2 errors. Type 1 errors are when the patent office issues a patent when it should not have issued a patent. And type 2 errors are when it made a rejection decision, when in fact it should have accepted the patent. And when we see these 2 error rates, it seems like they are not changing over time. So therefore, the inference there is that the contestability of the actions of the patent office is not changing over time. And therefore, to the extent that litigation rates are going up, it could potentially be driven by increasing value, expected value or the value of the litigation if you win the case was my suggestion. But there's no direct way in which I measure the former. The contestability part is the part that I'm measuring.
I think you have another research paper there, Deepak.
Thank you.
Hi. So this is for Professor Bailey. So I was wondering whether applicant citations are incorporated into the model in any way. So I know there's reason to think examiners don't use applicant citations of prior art very much. Should they, or does your model think they should? And sort of relatedly, do you check what an examiner might ultimately cite in a rejection or limitation as a sort of validity check on whether you're coming up with the right things, or how do you measure that?
Yeah, so I think the question about how do you take applicant information or potentially how do you take information from the crowd and use those as feedback mechanisms, one of the challenges is if you find, let's say, a knockout prior art reference, the question is do you share that, or do you kind of keep that close to the vest, or maybe you've designed around it somehow, or in terms of the way you've designed the claims. So I do not look at the application citations. I think, Jamie, we had a discussion with the examiners about that, and I think ultimately it was a signal that was a little too noisy to use, but I think that's a fruitful area for research. And then you had said about the ultimate citations that were there. Again, I think that's an area where similarly it would be great to include it, but it's right now not in the model. Thank you.
I'm told we have to stop in a minute, but let's do two questions, and I don't want to discriminate against the left side of the room. So maybe this gentleman and then Steve in the front row could have the last.
I saw something flash on the screen that really hurt me to the quick. It referred to stupid, broad patents. Now, is that simply exuberance on the part of the author who wrote the article, or is that something that should be seriously considered? The question can be, well, it was during Mr. Hedges' presentation that it flashed on, but anyone who can answer that, I'd appreciate it.
Well, so at least after the research I presented, I would like to say that it shows that it supports your characterization as owing to the exuberance of the writer there, right? And it seems, again, it's an example of how we take maybe anecdotes to characterize an entire system, and I think that was certainly what might have potentially been happening there.
I guess the rejoinder to that, Deepak, is would you characterize your results as being about, so you're focused on certain moments in the distribution, right? So you were asking something about the quality of the average patent, right, as opposed to somewhere out in the tail of the stupid distribution. Right? So does your research answer the question, this is partly a measurement question, right? So do the measures get at whatever that author was trying to get at? And secondly, if they did, even if you had that, there's sort of a distribution, right? And the question is, what percentage of the tail are things that we didn't need to induce innovation, as opposed to sort of the mean patent? Am I correct in thinking about it that way?
So I think certainly the data in terms of the allowance rates, we see that it seems like the patent office certainly is not rubber stamping applications, and overall about 55 to 60% of the applications eventually get issued. Now, does this 50 to 60% in fact include some egregiously bad examples? Very likely, yes. But is it lower than the conventional wisdom portrayed by the media that 100% are getting rubber stamped? Probably not. So in this sense, I guess we could argue that it speaks to the distribution as well as maybe the ability to allow these exceptions. But I cannot put my hand on the exceptions and make that characterization. It leads to a larger question about to what extent the patent office, given the limited resources it has, even has the ability to think about these exceptions in some sense. But it's hard to speak to that with the large sample data.
So I'll just say in academia's defense that George Contreras is working on a paper about what one can learn about the examination process from the issuance of patents that many have characterized as stupid and broad. Or broad, right? Right.
Steve, do you want to take the last?
So I agree with all the positive things that have been said about this development. But we're talking about a government agency, so there must be some constraints, and I'd like to hear a word about what the constraints are, what the review process for research questions or research design, whether the research whether replicability is possible by people outside the patent office, what the review process for publication is.
I'll at least speak to this so long as George allows me, but right, let's go in the other room. So one of the whole premises of some of the research we're doing is trying to get the entire data set out so it can be replicated, and not only, again, since these are limited resources, I am unfortunately probably not long for continuation as an Edison scholar, but I'm only one person anyway, and the Patent Office has lots of demands on their time as an institution, so as good as the Chief Economist's office is, having more people have access to this from outside will be really helpful.
I mean, I think I've been very lucky. The stuff that I've been doing seems to be resonating. I think, because there are, three of us up here, there are a few more Edison scholars, but you're talking about an organization with 12,000 people. Again, 8,600 of them are in the Patent Examining Corps, but, you're talking about a lot of institutional inertia and just not a lot of people used to academics floating around. When you say, well, they're there for a year, so we can just ignore them and they'll go away type of thing. No, I think for me, the biggest thing was, when I came, I was really passionate about what I wanted to do, and it wasn't until about halfway through my time there that people said, hey, wait a second, we're starting to get interested in what you've been interested in all along, so that's when things started getting a lot more traction there. And for me, it was just, fortunate that they kind of pushed towards improved patent quality, and this pre-examination search seemed to need an algorithm, and I just happened to be there at the right time. Because otherwise it would have been a fun year, but I think, I would have gotten my papers and gone back, and that's fine. It became a lot more fun job once people at the PTO started caring about it.
Okay, so I think we've reached the end of the scheduled time for this session. Thanks all of you for your questions. Thanks to the three of you for presenting your research. And I guess we have 15 minutes on for a break now, and I look forward to hearing from the next panel after that.
Okay, very good. Well, thank you. We're welcoming everybody back for a joint U.S. Patent and Trademark Office, Stanford University, Hoover Institution panel on the Academy's role in evidence-based policy making for intellectual property, hosted at Stanford University, Hoover Institution's Washington, D.C. office. This is the second of two panels. My name is Scott Keefe. I'm a commissioner at the U.S. International Trade Commission, and I am here to moderate this panel. Any other information I end up providing will represent, of course, only my own views, not those of my colleagues at the Commission or the Commission itself or its staff. I want to echo the great thanks to Shira Perlmutter and Steve Haber, the two co-organizers of this event. Shira and I are both alums of Penn Law School, and I followed a year or two behind Shira and was so pleased to see her not only succeed in the practice, but succeed in her academic career as well as in her government career. She set the bar high. I'm still trying to catch up. So Shira, it's just a pleasure to see you again. And Steve at Stanford University's Hoover Institution and a chaired professor in the School of Humanities and Social Sciences. Also an old friend and tennis partner. So our panel here is a very distinguished group of scholars, some in the government, some not, but all academically sound and authentically academic. So first to my left is Steve Haber, who I've already mentioned. Next is Jay Keeson, who is a law professor at the University of Illinois. Alan Marco, who is at the USPTO as well as an academic economist. And Joshua Wright, who is a commissioner at the United States Federal Trade Commission and an academic economist and an academic law professor on the faculty on leave at George Mason University Law School. So the topic for our panel is this is set up as a roundtable, so we will engage in dynamic back and forth. I will be trying to keep an eye out at the same time for audience participation, and if you have a contribution you'd like to make, please either keep it in the form of a brief remark or a brief question. Catch my eye. I'll keep a queue. We have two roaming microphones, and I'll try to, like an air traffic controller, line up the microphones, and we'll try to, I can't promise to be as physically active as Phil Donahue was back in the day with a baton microphone, but I will try to keep everybody engaged. So the topic for the panel is how can the Academy best contribute to IP policy? And what I thought I might do is just start with asking each panelist to give a brief remark of what you each think is the most important takeaway the audience should have in their mind when they think about this question of how the Academy can make a contribution to policy thinking. So let me start with you, Steve. What's a basic point?
Okay. Fast point is that good policy making starts with good research. That policymakers have to make tough decisions, and jurists have to make tough decisions, and they often look to university-based research to help guide those decisions. And if you were to compare the sort of literature about patenting in the intellectual property system to, let's say, literature like financial development, you would find that the ratio of serious empirical work in the two is quite different. There's a huge literature in finance. There's a very small empirical literature on patenting. The other thing that you would find is that there's the ratio of theory or theorizing or broad claims to empirical evidence is sort of very unlike other academic fields, particularly finance. So where there's a lot of theorizing in the patent space, very little serious empirical testing of that. What all this is to say is one of the things that academics can do to help in policy making is to broaden and deepen both the quantity of research and its overall quality, particularly in the empirical side of the study of the patent system.
Jay, you've done some academic law empirical research, and you're familiar with the norms of the academic law community. Are there any insights that this audience should keep in mind when they think about how that community works?
Yeah, and I just want to pick up on what Steve said. I fully agree with everything that you said, and that is, really, unfortunately, we're in IP legal scholarship, we very often just simply don't do things that are taken for granted in other areas. like, you couldn't get an NIH grant or an NSF grant without releasing all your data. It's required. There's a data management policy that states that. We, for instance, very often don't release our data. And so, nobody else can kick the tires and look under the hood. So I think it's those kinds of things that I think are more important. Is, hey, subject your work to scrutiny, get your work out there, put your data out there, be a lot more skeptical, and keep an open mind for some other inference from the same data that might actually be, just as likely. And I think those are the kinds of things that I'd like to see more of, and that's sort of one of the reasons why in a lot of our data, we've done our best to release everything.
Alan, in your role as chief economist at the PTO, another co-sponsor, co-organizer of this event, but also a producer and consumer of this research, I wonder, every writer thinks she or he has been to some extent misunderstood, or her or his field mates are being misunderstood. Are there some misunderstandings or misconceptions that you think are a little too frequent and it might help for this audience to be mindful about?
Yeah, well, I guess in terms of like misunderstandings are really misunderstanding how researchers would do statistical inference, right? So just what kind of inferences we can make from what kinds of data. And I think that's probably in my mind, that's probably the area in which the Academy can best help, but also the way in which I think we need to work the hardest, in the sense that policymakers see a lot of evidence, right? And I think most policymakers agree with evidence-based policymaking, but they also too frequently see just in the natural course of events, policy-based evidence making, where we've all seen reports on one side and reports on the other side that say completely different things, and it's quite difficult oftentimes for policymakers to be in a position to really tell good research from marginal research, right? And to really know when can I trust it. So I think that academics can be in a better position to better communicate that, and one of the areas of that, for instance, would be in understanding patents through the lens of patent litigation, right? So it's as academics, as economists, we're very familiar with the ideas of self-selection, and that the self-selected cases are not representative of the whole, and we just want to be as policymakers, right? We want to be careful about letting the tail wag the dog as far as that goes. So we really want to be careful about what can we tell about the population of patents from those that are litigated or those that go to the patent trial and appeal board. So I think that's probably the key one in terms of in the patent space.
Now, Commissioner Wright, Professor Wright, Josh Wright, you have the ability to contribute to this conversation from a number of perspectives. One is as a academic or government consumer of academic information, also as an academic producer of information, but then of course as a principal decision maker, you must feel a certain anxiety. I sure do when I'm asked to make decisions. I like to ground my decisions in something. What best helps you in any of those roles that I think might help this audience to know about? And of course, we're also streaming live to millions of audience members around the world watching us on the intertubes.
I'll try to behave accordingly. So, from my perspective, and I think sort of jumping off on what a couple of people have said, I think the primary role, and I'll sort of start from this and run into the FTC, the principal problem is inadequate quality control leading to overbroad claims, right? Sort of a combination of the high theory to empirics ratio. In fact, I think this is a theorem of legal academia where the empirical evidence is low, the claims get louder, right? Because you can't point to data, so you have to amplify somehow, and volume seems like a reasonable way to do it. So papers come out in all caps and things. And you change a million to billion or however you choose to amplify. So I think the obvious way and the most important way for the academy to contribute is to do and take seriously both elements there, the quality control and the retailing. I mean, if you compare in terms of the quality control, you have an interesting problem. So the two worlds I come from in this sphere, antitrust and IP. If you can compare the claims that are allowed to be taken seriously in the antitrust world, where I think the norms about scholarship are a little bit different. In the legal academy, for example, the claims are more modest and certainly more tethered to the actual inferences that an economist would say are valid with respect to what studies show. That tethering, I think, is absent in the IP scholarship world. And there's a lot of reasons, and we can get into some of what they are. Some of it has to do with peer review. There are some other things. But for me, I think what I see as absent in that literature is academics sort of taking more seriously their duty, their obligations to participate in quality control. That ultimately leads to these sort of overbroad claims. And I think we just become awash in claims that are out there about that are equally loud and an equally big font with one with a negative sign in front of it. And don't, as a policy maker or a decision maker, aren't left with a way to discriminate between the two. I have a way out of this. I can run the regressions my darn self and ask for the data, and if you can't show it to me, I can disregard your paper. Or I have a staff that can do so better than I can, and I can try to get at the data myself, and I do that as often as I can. I think, and Jay mentioned this, some of the intellectual property scholarship, even norms about availability of data and replication, seem to have been discounted or disregarded in some context, and that just, whatever the end result is, that's just a troublesome development.
I wonder, are there, do any of you have ideas that you think would be relatively easy to implement in the short term, whose wisdom would be so attractive to the group that the group would choose to adopt it, that might in the short term improve by some measure what happens in this literature so that the literature is more useful? In other words, there are debates, you've alluded to some of the causal factors, each of you, about why the ways in which the literature is not as helpful as it could be. But are there easy pickups, easy wins, easy ways to make it just materially better at relatively low cost?
I think the answer to that is yes. I think that the PTO Edison Scholars Program is a step in the right direction there. The core, the core problem is that there are, I'm going to put this as delicately as possible, there are not enough economists in this business. And there are a lot of $20 bills sort of laying on the ground for economists to pick up by moving into the study of innovation. Because economists bring a sort of a rigor about evidence and method in which people in the legal academy have not been trained. That's not what law schools are set up to do. They're set up to train advocates. I'll provide a parallel to this. One of the fields that's really changed in the last 20 years is a field which I'm a professor, with political science. Political science today is a completely different discipline than it was 20 years ago. There are several reasons for that, but one of them was that economists started doing political science and publishing in political science journals, and they simply upped the game. The other was that journal editors then turned to economists to write the referee reports for political science journals. So in this state, so the flagship journal of political science is the American Political Science Association. Half of the referee reports are written by microeconomists. That has just changed the standards of publication and therefore changed the standards of evidence and proof across the discipline. That's something that could happen in empirical legal scholarship. It means bringing more economists in and creating institutional fora to do that. One of them is a series of conferences that we run at Hoover IP2. Another is the Edison Scholars Program at the USPTO. I know there's other initiatives that are run at Kent Law School. And I think as more and more of this happens, it'll help shift the discipline.
Yes.
Can I jump in on that one as well? Because I think coming at it from the PTO side or from the agency side, I think an easy win is that I agree in terms of transparency of data with respect to researchers. More researchers should do that. My advisor was Bronwyn Hall. She always does this, and I learned that from her. One of the things that we can do is, data oftentimes is a public good, and so that's why one of the primary roles of my office is to push that data out as much as possible, well described, understanding the institutions behind it, and helping researchers to understand the data better, so that we don't have isolated scholars having to reinvent the wheel and parse XML code just to be able to use the data. Let's get it out there, and when a government agency can do it, all the better. We can make it available to everybody. More replication, more transparency, lower transaction costs.
Now, I'm curious to follow up on something Commissioner Wright had mentioned that dovetails with what each of you has mentioned, the notion that the IP literature, the patent literature, has been, at least in the law community, materially different than the antitrust literature. So I'm curious, has the IP antitrust interface benefited from the richness of the antitrust literature's standards, or suffered from the shortcomings of the patent literature's standards?
Both effects are there. I think the benefits have outweighed. And in large part, this is, I think, agreeing with Steve, it's the same economists, right? So the same economists that have sort of helped rationalize the development of antitrust law are around in quality and numbers, working on the interface of IP and antitrust. Sometimes, and this is, I think, the cost side of it, the institutional detail side of that, of getting the work, suffers. Or, more importantly, if I'm an economist in graduate school looking for a topic to write on an IP and antitrust, I go read the law journals for what's important. And you get, well, a lot of shooting at $64,000 questions and not picking up the $20 bills. And there was, in the 70s, 60s and 70s and early 80s, a big economics of innovation literature that largely threw up its hands at the end of the day. It was trying to do $64,000 questions like the relationship between market structure and innovation. Turns out, 40 years later, we don't know. In large part because everything was endogenous and people didn't take causation seriously, but also it was hard to measure innovation. The latter part's still true, but the one advance that I think has happened in industrial organization economics or applied micro generally is there has been, in economics as a standalone field, the sort of credibility identification revolution sometimes goes a little bit too far. But this is Freakonomics and all of that. This is the trade-off between doing big kitchen sink regressions that I don't really learn much about at the end of the day versus doing something narrow where I can identify with strong causal inference some relationship about the world that on its own we're not going to pass a piece of legislation, but we get a real drop in the bucket of knowledge that people believe, and then someone else drops another bucket, and eventually in 10 years it's full, right? And this is, I tell my students, you don't believe papers, you believe literatures. And you get literatures by getting a lot of people to think harder about causation, accept smaller projects, fill up the bucket, and then make policy. And I think one of the things that is distorting the patent literature relative to, say, the antitrust literature is that sort of marginal approach was taken in the antitrust field, and I still think you got a little bit too much. I've got a paper pass a bill going on in the patent field, and
biting off more than one can chew.
And I think the answer is, and you know, the economist says the answer is more economists, so he's surprised. But I think that's the answer: is more economists and more economic methodology that comes with it.
And in the interest of full disclosure, you wear both hats.
I wear all of the hats, and one more because you just reminded me. So there's a camera on. So I need to say the thing that you said. You can only blame the things I say on me and not other commissioners.
Steve and Alan, you each had follow-ups.
Yeah, so one of the things that Josh said about causal identification, I just wanted to echo and stress its importance. And it came up in Deepak Hedge's presentation in the last session. And that is that one can look at a piece of data and draw many inferences from it, some of them accurate and some of them spurious. And I sort of call this sort of data analysis without theory. So the perfect example of this, if we see it again and again and again, it comes up in Congress and in other places, comes out of the White House, is increase in the number of lawsuits. Well, you can draw lots of inferences from that, and the inference that people seem to like to draw, particularly coming out of the legal academy, is that the contestability of patents has gone up, therefore the patent system is broken, therefore we need to fix it. As Deepak pointed out, well, there's another inference you could draw, which is that the value of intellectual property has gone up, and therefore people are more likely to litigate over it. Based on just a graph with time and the number goes up, you can't separate out which of the two, right?
Or others.
Or others, right? So I think that from the point of view of policymakers, it's important to keep in mind that just because a particular academic wants to draw an inference doesn't mean that's the right inference. And from the point of view of academics who are operating in this space, unless you're working from a very well-defined body of theory, in which you then don't have to worry as much about causal identification, if you're not, then you have to really worry a lot about the inferences you're drawing from the data when you're engaged in a sort of data gathering enterprise.
Alan, yes.
Yeah, I wanted to also give a caution, because one of the problems in bringing a lot of economists in is that policymakers really will have high expectations, right? And I do find that they tend to have high expectations because you get it goes back to, I think it was Churchill who said that he wanted the one-handed economist, right? But economists relative to let's say legal scholars, we tend to be a little bit more reserved in our inferences, and so it doesn't get a lot of fanfare. And when someone says, okay, well, we got some economists in here, what we need to know is how much the IP system is worth to the U.S. economy, or how many jobs does it create? Those big questions, right? These $64,000 questions are the ones that economists will say, well, I can't really answer that. Here's what I can answer. You see this little piece of the puzzle over here that's kind of surrounded by these other pieces. I can probably fill that gap. But it's going to be, over time, we're going to need to see a literature develop to fill these gaps. And that's something where I think a lot of times policymakers need to be really just more patient and more understanding about the limitations for doing good empirical research. We can do bad empirical research and answer those questions, but we want good empirical research. And if we do that, we have to answer smaller questions.
Just the fundamental, on the demand side of this, the fundamental truth of the legal academy in economics and in law is that you can get tenure as an economist answering this question.
Right.
And you can get tenure as a law professor making absurd claims about this question.
Yeah.
All right. That drives a lot of the gap, and I think that this is just Jay's, not mine, but to the extent that law journals required publication of data, at least to the journal itself for replication. Right? I mean, you look at the 10 most cited patent papers of the year by policymakers. 9 of the 10 will be in law journals, not economics journals.
It does take an extra 18 months to publish in econ.
Right, and that's the other. That's another thing that maybe.
Although working papers in all of these
Right.
get published earlier, but
Right, if you want to put them out there and so forth. So there's the trade-off. It takes time, and maybe you can't have as much policy punch because of questions today. But in terms of where we are on the sort of marginal return of the truthiness of patent scholarship versus the delay, I'll take the delay.
I wonder if you think about all we're starting the summer. I'm wearing a summer suit. It's hot and humid in Washington. But that means that academics all around the world are rolling off their teaching loads, thinking about where to deploy themselves for research. I wonder, do any of you have, or the audience members, have ideas that you think fall into the category of $20 bills, bite size, practical payoff, tenure-worthy literature contributing, and you know, even if they're not over the fence home runs or sky high dreams.
So, I'm happy to get things started, and then I'll give my colleagues a chance to think of something more intelligent to say. That was a joke. I didn't get any laughs. It's a tough audience.
It was more of a groaner than.
Yeah. So, you know, I think there's one. So if you look at the sort of the debate that's going on the Hill these days, a lot of it is about patent trolls. And what we actually know about the business of patent trolls is minuscule compared to the amount of noise there is in the media about them. So I think an obvious place to begin to look is at the actual business of patent trolls. And I think a specific place to look, a specific research question, is a patent troll a financial intermediary, or is a patent troll a predator on the innovation system? The theory of finance would suggest that intermediaries arise when there's some asymmetry in a market such that there's a return to an asymmetry. In the sort of patent space, that would suggest that the asymmetry is between sort of individual inventors and small enterprises and the large firms that implement those, that are the implementers of those patents. So as an hypothesis, one could test the hypothesis, is the behavior of patent controls consistent with financial intermediaries or consistent with a mafia? It's a question for research, but it requires first asking the question before you can actually conduct the research.
Jay, do you have any thoughts about?
So yeah, I'm spending a part of my summer looking exactly at behaviors of various kinds of patentee plaintiffs, you know, universities, individual inventors, trolls, all these people, and seeing if there's actual differences in the way they, you know, settle, take cases to trial, or hit and run, or lose all the time, or all of those kinds of stories that are out there, and doing it very carefully, and all the data will be public.
In my teaching career, I taught a fair amount of intro classes, and when we talked about policy, I would try to tell my students that you really want to focus on, when you think about good public policy, you want to be thinking about, number one, answering the question, what is the market failure, right? Identifying very clearly what is the market failure that we're trying to intervene and trying to solve. And I think that a lot of times in the patent space and IP space, we take the system as a whole, and people will ask the question, is it broken? It's a system, right? And there's a lot of component parts. So I think that one of the one of the areas where we could refine the analysis fairly quickly early on would be to identify those component parts. Look, there's certain things that happen at the PTO. Does the patent examination, patent prosecution, does that affect, to what extent does that affect the way the patents are used later on? Does it not? In what ways does it? That answers whether and to what extent the PTO is in control of certain parts of it. To what extent is it applicant behavior prior to coming into the PTO or during prosecution? To what extent is it changes of ownership, or there's simply a different, is it just a different business model for these intermediaries or non-practicing entities? These are all very different parts of that vertical relationship. And I think that those are really important to identify and to clarify and to understand the distinctions between them.
Okay, one quick comment, which is, I think in line with those comments exactly, is I think one of the roles for government institutions that came to mind while you were talking was, yours and mine. The source for demand for research that picks up $20 bills is either got to be the legal academy or the government institutions. It's got to be one of those two. Having been tenured in one of those and now working inside another one with some form of tenure, Humphrey's executor and all that.
Yes.
I would put my money on the government institutions over the law schools on this
Yes.
one, and precisely because things, precisely what Alan was talking about, are going on at the USPTO. I think at the FTC, we've played a role in some areas. A 6B study that's coming, for example. What I think we can do better is create demand. We talked about different components of the USPTO and identifying research questions and testable hypotheses within these individual components, I think is a really healthy exercise for any problem. So if you look at the 6B, which I think is the FTC is wonderfully suited to do, we'll go out and get data. The research design is to do something modest and descriptive and contribute knowledge to the world, put the data out there and let people do what they're going to do. I think that's great. Now the press release for the thing says, patent trolls, are they good or bad? Is consumer welfare going to go up or down? You can't read the research design for the study and believe we'll be able to answer that. We won't be. Again, the things I'm saying are just mine. We won't be, but it will be a valuable piece of research. Incredibly valuable, because I think it will provide some institutional detail that will let people pick off smaller parts of these questions. But I think government institutions like ours, and particularly the economists in them, need to be mindful about identifying for the world and for graduate students in particular, and young economists looking for projects, what things the world values as $20 bills, what's worth doing. And for my lights, I think the more, just sort of in terms of the statistical inference, the more seriously causal inference is taken, the better off we'll be. And if that means going incredibly smaller, I'm all for it. I'm thinking of, Heidi Williams and her co-authors have a paper that's an AER and a follow-up paper where to call this a $20 bill, it's absurd once I sort of say the topic. It's using natural variation and the strength of patent that come from when the trial ends, from longer-term or shorter-term cancers, right? And so in trying to test using natural variation, you observe, not from reading law journals, but from looking out your window, using natural exogenous variation in the strength of the patent to look at investments in research and investments in innovation. That is, one, wonderfully clever as research design, gets at a really important problem. At the end of the day, it's about the relationship between patent strength with respect to cancer drugs and innovation, and it's a drop in the overall knowledge but it's a believable one because of the research design. And I'll take that over 100 law review papers that don't take causation seriously any day. So I want to make clear that when I'm talking about the $20 bills, I'm talking about narrow, well-defined research design and causation. Some of these are still incredibly important papers.
So let's go out to the audience, and as audience members speak, just please give us your name and organizational affiliation. We have first in the front row, then we'll go to the third row on the left, and we'll move around as others please.
Thank you. Saurav Vishnupak, the U.S. Patent and Trademark Office. to pick up on Commissioner Wright's point, the literature on the patent system, a lot of the things that sort of purport to be about the system as a whole often discuss effects that are often idiosyncratic, if not altogether unique, to particular technology areas. And we often see it coming from places and institutions that are very well versed in those technologies. So I'm not surprised when I see really good tech scholarship coming from Silicon Valley and venture finance coming from Silicon Valley, and pharma and biotech coming from the Northeast, New Jersey, Philadelphia, and so on. So do you think there is value in using those comparative advantages and focusing on research that is specific to industry and really getting at the institutional details that you sort of talking about, and also about particular modes of translation from the university to the private sector, from the government to the private sector? These are in fact examples of particular ways in which you could carve up the research into manageable bites and get meaningful results.
Any reactions from the?
Yes, yes, and yes.
Okay.
Agreed. Yeah, there used to be a lively field of industry economics in which people knew the institutional and technical details of industries. There still are people that do it, but it's, I completely agree with the idea that knowing the details, the institutional details of particular industries and the technological details of those industries matters a lot. And I think that there is beginning to be some scholarship along those lines.
We have 3 questions teed up, Josh, George, and then Steve. Why don't we ask you to each ask them and pass the microphone up, and then we'll take some feedback, and then we'll move back to the queue. Please.
So it emphasizes the difficulty of asking the right questions about the right data and actually being able to get access to the data as a very hard part of this. I'll just give 2 quick examples. One, if we think about the so-called trolling problem, one would expect to see a high number of Rule 11 filings in the courts, that these are unjustified lawsuits. Very few people have studied that, and even if they did, you would have to then disaggregate between the choice not to bring the Rule 11 motion and the reasons for doing that. That's very hard to collect the data. You have to interview people. How do you code it? It becomes very expensive and quite not necessarily reproducible or accurate. Similarly, we know almost nothing about the licensing market, trade secrecy issues, so hopefully the 6B study will start to get at that. But my guess is there's not a systematic requirement to collect all the data that one would want to know about what happens to patents in the marketplace, which would require a dramatic change to the amount of data we collect and a dramatic cost. Only government can do that.
Data is very nice to have. You collect tons and tons of data, but you have to be careful not to use the data in a manner that it isn't intended. It reminds me of the cat jumping on a hot stove, then it jumps off, and thereafter won't jump on a cold stove either. So you have to be careful how you interpret the huge amount of data that is available.
And then if one more, and then we'll gather reactions.
None of you have said anything about the funders of research. And so I'm wondering what you would tell potential as well as current funders about increasing the quantity and raising the quality of research. I'm thinking of not just, as I said, current funders, but the number of foundations that used to be active in intellectual property and have largely withdrawn. I'm thinking about the NSF Science of Science and Innovation Policy Program, which ostensibly this is at the center of their set of concerns. It's somewhat in flux, probably amenable to thinking more seriously about this.
As Commissioner Wright often makes a humorous remark appropriate for this about spending other people's money, but
I'm for it.
We're all for that. As long as I'm not the other people. No. I'm curious, do you each, if you each think about organizations other than your own, and you each think about foundations and government organizations whose business model includes a significant devotion to financing academic research, what are some things you would want them to keep in mind?
I just want to pick up on what Steve mentioned. I think part of it is also because as the quality of the scholarship in an area goes down, it is seen as being much more a political football as opposed to sort of doing good normal science. And when you do good normal science, you actually end up getting more funding and you end up getting more attention instead of sort of having some debate of whether you want to have chicken salad or tuna salad for lunch. And I think that that's partly what is happening here, is that even places like the NSF, you mentioned the Science of Innovation Policy, is a good example of where I think it really is important that we take on the burden of convincing them that there is, good normal science that can be done in the area, and that will help a great deal.
Just take a second on this. So, innovation policy is one of the few policies that are more important to the future of the United States than getting innovation policy right. There are many things to focus on, but innovation policy has certainly got to be in the top 10 if you think about America's future. The amount of sort of funding of studies of innovation policy by the government relative to the importance of the task is not sort of commensurate. And that means that either the government will do it, private entities with vested interests will do it, or no one will do it. And my bet would sort of echo something that Josh said before about the government versus law schools, which is that my money would be on the government. Because if you want to have, as I think about the finance literature, who funded most of it? The Federal Reserve. There is, nothing but academic economists sitting inside the Fed doing nothing but research, and nothing but financial economists who go and visit it at the Fed for a year, 6 months, 3 months. And it created a robust literature, but also affected the sort of the culture within the institution. So my money would be on more government funding.
Alan, you had a brief remark. A quick interjection on the chance that it helps. I think it was Kettering who ran research at in the auto industry and who was famous for talking about innovation in the future, and was once asked why he was so focused on the future. And my understanding is his answer was that he had hoped to spend the rest of his life there.
So I wanted to address the one question in part about we need to interpret the data as it's collected. I think that's incredibly important. And understanding those institutions are exactly, I think, one of the reasons why I think the Edison program is successful, is that we get people in the door and really understanding, talking to the examiners who are creating the data that they're interpreting, right? Because the data that we have in-house was created through the examination system, not for the purpose of studying innovation. It's for the purpose of tracking these transactions, right? So we need to interpret the data as they're collected. And it's also one of the reasons why my office likes to spend time when we're doing a data release, spend a lot of time on writing up the data and the pitfalls in using it, and the do's and don'ts, and kind of what to think about it, so that it can get out to the research community. We want to do it once, though, so every researcher doesn't have to learn it over and over again. And so that's where I think that really the public goodness of these data, it lowers the transaction costs. So in terms of, I haven't thought as much time about the funding side of it, who we're funding and in what areas, but if we reduce the transaction costs of accessing the data and understanding the institution, we're going to increase the supply of that research down the road.
to tackle a slightly different aspect of the same set of questions, both with respect to the demand for the data burdens of a particular project and with respect to the danger of bad interpretation, the cat on the stove. Let me go back to what I think is, to me, the fundamental piece that's missing in the quality control of all of this that reduces the problems with both of those things, which is research design, and research design. To the extent that one knows the institutions and can learn the institutions, you find natural or quasi-natural experiments that you would not know without a deep understanding of the institutions. This is in part what I think helped the antitrust literature in I/O, was you got economists who became antitrust economists. And they learned, and you had studies looking at, different diff studies or triple different studies looking at variation in state law, or this law hits this industry but not that one, or so forth and so on. People started looking out their window or inside the windows of the PTO or the FTC or DOJ for natural experiments, which gave you, one, reduce the burden for the data you need to collect if you're going to run some big kitchen sink cross-section. You need less stuff because the research design identifies what it identifies. And two, it reduces the bounds of interpretation because you've thought up front, you've shifted the work from doing 3 years of collection to doing 1 year thinking up front about how to get the design right. You can't do that all the time, but the problem in I/O with getting contracts that aren't licenses, it's the same thing. AT&T didn't want to give anybody their contracts, what they were charging, and so forth and so on, or exclusive dealing contracts and the like, and that got solved. There's now a literature on all of those things, and people point to it and believe it, and so forth and so on, but it's solved by commitment to research design.
Jay, you wanted to make a brief...
wanted to just pick up on, I really think it's a combination of both academia and government that really has the power to really do a lot of good work, because, and I think of, I just went in when I did my Edison Scholar stint with this, just, hey, let's try to get at this one handle, let's try to get a handle on this one issue, which is the USPTO so much better or so much worse than the European Patent Office? I mean, that was sort of the basic question. Hey, everybody says, oh, the EPO is so much better than the PTO. And I was...
Mostly EPO.
European Patent Office.
Yes, so mostly EPO.
Yeah. Sorry. Of course. But yeah, and so I would never have had access to a matched set of applications, U.S. originating applications prosecuted in Europe, European originating applications being prosecuted here, with the same underlying inventions, going back to research design, so that I had a matched set that I could really look at and go and talk to people who actually knew the details of European prosecution. So it's really the fact that I was at the PTO and I was able to do it, not only get access to data, but talk to people and so on. And so I think and of course, it became very clear to me that it was a very complicated problem to get a handle on. But really, it's an example of the kind of synergies that are possible with the Edison program.
Let's go back out to the audience, please.
So this conversation has already covered some of this, but I wanted to sort of echo Joshua's point about the central role of kind of the private market, for which we observe no prices and no quantities in thinking about a lot of the important policy questions here. And Commissioner Wright sort of said, oh, in antitrust, there's a parallel to contracting. My read of a lot of that literature, and I might be wrong here, is that the influential work there has really been kind of theory on contracts as opposed to, unless I'm missing a large literature that uses sort of private data to do empirical work.
Literature.
So, okay. And then the other, sort of riff I wanted to see if I could get you to go on a riff about, if we flip what is the Academy's role in evidence-based policy to what is the policymaker's role in interpreting academic evidence, should we expect the policymaker who has to sort of bootstrap, right? If we accept the premise that a lot of this is bad, that there's a lot of bad studies out there. Suppose they know it do they need to sort of attach the referee report to the press release when they're going to do something? Or, you know, sort of what's the standard of disclosure that the policymaker is held to on, in terms of sort of the transparency and in what evidence they rely on and how?
Well, I think a simple answer to that is, from the point of view of a policymaker, is to ask the question, was this piece of evidence published in a peer-refereed journal or not? I think that's a very simple metric that can be applied very easily. And I think it's something that policymakers can easily ask one another, as one touts one study over another, is to ask first, well, was this peer refereed? The second thing, as I would go back to something Josh mentioned, which is that it is never the case that one study about anything is dispositive. And so the question for policymakers to ask isn't, is there a study that claims? It's, is there a literature that the weight of which points to the following conclusion? And that's again something a policymaker can ask another policymaker without having to, you know, dive into the details about did they do diff and diff or was this RDD. They can simply ask, well, is there a literature? And was it published in peer-refereed journals?
And if there isn't, then I think policy making in general needs to be patient to say, okay, if there's a gap here, let's look 5 or 10 years down the road. And policymakers don't like to do this, especially if they're getting pressure from certain constituencies. But we really do need to ask that question: where do we want to be in 10 years? What kind of questions would we like to have answered in 10 years, and how do we get there? And let's be patient, but let's make decisions now that will get us there, instead of saying, well, if we don't have the answer, then let's figure something else now, and then we'll wait for the next person to have to figure it out.
So my response on the antitrust is going to be agreeing with you more than it sounded like, which was not at all. So the theory literature is there and has been influential, but if you look at exclusive dealing literature, there's 30 or 40 papers now that are mostly diff or better in terms of research design on effects on P's and Q's and innovation around exclusive dealing. The RPM Supreme Court decision, the law changed in part because of empirical studies. Tying the same thing, horizontal merger is the same thing, vertical merger is the same thing. There's a lot to do in those areas, right? But our current bureau director, Francine LaFontaine, produced a bunch of these herself. But you know, there are now literature reviews on literature reviews of the empirical work that's been done and its influence, and it's cited in Supreme Court. It'd be hard to argue the empirical work's not been influential, which I hope is not read as the theory has been. You know, you got to cite Steve Salve somewhere in there too, right? Now, the difficulty, I think, is most of those studies observe either P or Q, right? Now you can get away, this is the part where I'm going to agree with you a little bit, you can get away with observing the contract, right? If you have the P or the Q, right? You have variation in a state on whether the type of contract's allowed at state level or local pricing. You can do something with that, right? And I think the problem there is in most of the economics of innovation, most of the time we're less interested in the P or the Q, and we're more interested in measuring something like the rate of innovation or investments made in innovation or so forth and so on. And that, it's not that it's not observable, it's that nobody agrees that it's measuring anything. And I think that's a different problem, right? So whether we're going to use patent citations or whether we're going to use dollars spent on R&D, so forth and so on in terms of the measurement of innovation. That's a harder problem than measuring prices. Has been for 50 years. But there are papers, like this Heidi Williams paper that I've referenced, I think handles this quite beautifully. And it's not that it does anything that people haven't thought about for a long time. It identifies identification in a creative way. It doesn't get you everything. Sometimes you're going to want those contracts. You want them in I/O for antitrust stuff too, and sometimes you can get them. Sometimes it's through the government doing stuff. Sometimes it's through FOIA. It's other things. I think that the measurement of innovation problem is systematically different between antitrust and IP and leads to a lot of differences. But in terms of the observability of underlying contracts, I think that part's pretty similar. and doesn't solve, sort of research design doesn't solve all of it, but we're not close to being at the top of the hill in terms of the marginal gains from doing a little bit more, right? I mean, I can count the number of studies that have done serious peer review level research design in this area on both of my hands that have been produced in the last 15 years. That's, it would take everybody's hands and fingers to do that in antitrust. And I think, so as long as that's true, I'll take not fixing everything at once. If we can get 4 more good papers.
I wonder if there's any advice, even if it's just framing the question or framing context, that you would give journalists who write about this, staffers on the Hill who talk about it with each other, not with an eye towards impacting anything before any governmental agency today, not with an eye towards impacting any piece of legislation today, but with an eye towards, over the next few years, how to be most helpful. Are there particular takeaways that that an audience like that could enjoy from a conversation like this?
That's a tough question.
Well, let me try it this way. I guess it seems like you've all said that looking to law schools to generate this research may not be a high payoff area, at least for not looking to non-peer reviewed work out of law schools. So instead, looking to peer reviewed would be helpful.
I guess also looking at some of the same things that Josh and Steve were saying about looking for a literature. Say, is this result consistent with a literature with something that we're seeing now? I don't know that they're going to journalists are going to necessarily take the time to do that, but it could be that.
But it's a question they could ask folks who are talking to them. And just to make sure I and they understand, by literature, you mean, I take it, 2 things. Not merely the presence of a large number of papers, but the diversity of perspectives, the degree of contesting that has gone on within or among the papers. That is what constitutes a literature, not a chorus.
Also, if they read, say, a book like How to Lie with Statistics, or some of the other very good books out there. If journalists were knew a little bit of statistical inference, it wouldn't hurt. Maybe it's a pipe dream.
Yeah, I mean, I think what is really needed is caution on both sides. I mean, I find that when I talk to a congressional staffer or so on, I take extra trouble to make sure that the limitations of what is in my study is very clearly laid out. I sort of take extra trouble to sort of point that out, and I think that that's something that I've become sensitized to after seeing the way my work gets consumed. It's because while it doesn't really support what you're saying, and so you sort of become sensitized to that. And the second thing is, on the other hand, if you are a staffer or if you are a policymaker, then I think it's worth sort of asking someone who is an academic, saying, "Hey, well, what about this other paper? What about this other? Hey, this seems to disagree with what you're saying."
So I think that from the point of view of journalists and Hill staffers, I mean, I think that there's sort of 2 things that they can do that are low cost. One is to just learn that Google has a thing called Google Scholar, and you can go on it, and you can type in a topic. And you can see whether or not a review essay pops up about a literature. And you can just see whether that review essay was published in a peer-reviewed venue. And you can read at least the first 5 pages of that review essay before it gets down into the weeds and get a sense of what the state of a particular literature is. And I think that's fairly fairly low cost thing to do. I also think that, and I think that there's something I think that academics can be doing, because remember this is about academics' role. What we should be doing is that particularly journalists, Hill staffers, and academics need to meet each other on the turf of the press and Hill staffers, not the other way around. That we should be better at making our work more accessible and making ourselves available.
Well, along those lines, I wonder if any of you has ideas you'd like to offer organizers of academic work for them to keep in mind as they conduct their work, so that it's most likely going to be impactful to the policy and decision-making community. So, for example, should they have a governance structure that is mindful of their source of funds? Should they have a governance structure that's mindful of fiduciary or other duties they might owe that are independent and thereby potentially conflicting with a reader's natural impression that writing represents true independent academic work rather than a professional agent's action on behalf of a client or customer or patient to whom they owe some professional heightened duty of candor or fiduciary duty of loyalty. So, for example, of course, lawyers owe duties to clients to further the client's interest over the interests of a lawyer. Does that mean that lawyers have to be especially mindful when they put on their academic hat to serve as an academic, that they not simultaneously have an advocate obligation, a professional lawyer obligation to a client? Should they discharge those two obligations in a particular way to help policymakers? I don't know if any of those are, if any of you wants to weigh in on any of those topics.
A lot of journals do. A lot of journals, you know, peer-reviewed academic journals do require that information. I think that's more transparency, more understanding of those relationships is absolutely important. I think those even in those cases though, it can be misunderstood in the opposite direction. To say, well, simply because Jay may have been an Edison scholar at the time that he did this research, and it's something that happens to look favorable, that comes out looking favorable to the PTO, then, well, that means we can discount that, right? So, because the peer review, I think one needs to understand the peer review process is still there for that purpose, right? But on the flip side, I actually think that economists are notoriously terrible at making their results understood outside of their narrow field, because we can get tenure writing a very narrow research on a very narrow research topic and getting it published in a peer-reviewed journal and read by 20 people at a time. If we're getting tenure, that's what the institution is driving us towards. The MBER, I think, is quite good at this in terms of their working paper series, because they're now coming out with a lot of sort of two-page summaries that are very well understood, and something that a lot of other professions have been doing for a long time, quite good at. That, of course, still leaves the policymaker with the question of, well, I read this two-page summary and this two-page summary, and I have a hard time telling the difference between the two. So it still gets back to a reputation of the journal or the institution that's behind it. But I do think that communication side, it's incumbent on the academics to improve their communication to policymakers.
Josh and then Steve.
Yeah. So one general observation about the role of the academy, and then sort of two more specific ideas. One is that one thing that happens in the field of economics when somebody publishes a very bad study, maybe even gets it in a peer-reviewed journal, but you did something bad with your coding, you tricked the peer reviewers, you made up the data, whatever. Bad things happen to the careers of these people. There are reputational sanctions in economics that best I can tell either don't exist or exist sort of with less force in law. And I think there is a different culture, and there's some benefits to that different culture. Everybody high-fives each other and says their papers are brilliant, and that's fine. You get a lot of high-fives. But I think that there's less of a culture of saying, a paper is bad, and that paper shouldn't influence policy, and here's why. There are some excellent examples of such papers in legal academia, one authored by Jay. But I think it is not common. And I think part of that is cultural within the academic sphere. And to the extent data are now more available, I mean, this culture developed when no law professors didn't do empirical stuff. Mm-hmm. But that culture is still there, and I think with the availability of data, any law professor with Excel and a data set can run a regression, without a license, and that's fine. But I think that culture is not serving legal academia very well, and should change. So I think I'm taking the pro-shaming position in terms of what the legal academy should do. I'm for more shaming of law professors. Don't hold this against the other commissioners.
Law professors who do bad research.
Who do, at least those ones. Now, in terms of specific recommendations, this is one everybody has made. But when we're talking about problems over funding and the like, having a system in which data is either made public or at least replicated by the referees for the journal, as is very common in economics journals, I think reduces the fights over your industry funded, your government funded. Either it's public and you can, if you've got a problem with where I got, replicate it, right? And I think that tones down. You'll still have, he was paid for by whomever, and that's fine. But you can, this happens all the time in other fields, and having the ability to replicate solves a lot of those problems. The other thing I would say, getting back to the point about retailing and caring about retailing one's results, the first thing I would do if I was a law professor without tenure interested in this field right now, there is obviously a high demand for objective, dispassionate collection and publication of interpretation of results in which one can develop a reputation for being reliable and objective. So meta-analysis of particular fields, similar to sort of a lit review, takes a little bit more technical skill to do. So you grab yourself an economist co-author and do a real lit review of the field. Very Journal of Economic Perspectives and such in the economics field, very common, really heavily cited. You get tenure on that alone. But just not done. Not done. Pieces criticizing this paper or that paper, but in terms of sophisticated literature reviews. These guys got different effects. Here's the range of effects. Here's the midpoint of those effects. Here are the confidence intervals around them. Here's policymaker, law professor, interested reader, family member who reads my papers. Here's what you should think the takeaway is. We don't have that, and I think there's significant value of it.
It was significant value to policymakers.
And before we go to Steve, I just want to ask Professor Wright, in your capacity as a law professor, when you talk to law students and you teach them about professional responsibility that a lawyer has to a current client, and you talk about the duty to put that client's interests first, do you think that there's any anything that audience members should keep in mind when they read an academic piece that is generated by a legal academic who is at that time serving as a lawyer for a client, compensated or uncompensated? Does that lawyer's duty to represent the client's interests, should that matter at all to the reader, and if so, how? If you could educate the audience about that a little bit, because they may not know that there are these special duties that lawyers owe clients.
I have never had the privilege of teaching professional responsibility at George Mason. And if my future dean is watching, I'm not asking for it. However, look, I think in antitrust this is very popular, right? You get white papers and academic publications by the firm's lawyer. Happens all the time. Sort of gray-space quasi-academic papers. And some of them quite good, and some of them not so much, because the lawyer has a reputation and he has lots of clients, right? And some of them quite good and quite not. I read them like briefs. Some briefs are really good. Some briefs are not very good, but I treat them like briefs, except if there's empirical information. If there's empirical information, then the fundamental question is whether the thing is, you present me a paper, I mean outside the context of litigation or appearing before the commission, in an academic piece that presents data and results. If I can't see them and touch them, then no matter if it's a good brief, they get 0 weight.
So maybe just a follow-up. Should a reader keep in mind that a lawyer currently representing a client in a matter who has taken a position on the topic that is being written about can't advance to an academic audience a position inconsistent with his client's or her client's position?
I don't want to pretend to have any expert knowledge about whether there are legal limits on this. I will say, as a reader of such studies, I have a healthy skepticism that goes into reading all studies, and maybe sort of a beyond a healthy skepticism
that would be
for paid-for advocacy, including that form of paid-for advocacy. Now, that's a rebuttable presumption in terms of reading the document and seeing if it changes my priors. It's rebuttable by good work, and good work depends on whether it's legal arguments that I read one way or empirical arguments that I read another way. But I would certainly be willing to concede that the skepticism meter goes up a notch or two in that context, as opposed to sort of normal advocacy.
Steve?
This is sort of touched on interesting. I've learned a lot, mostly about the legal academy, and someone who comes from outside the legal academy, I've been impressed by sort of, I want to put this. So if you're in a field like economics, or you're in a field like political science, or you're in another field, the presumption is that what the field is about is getting to the truth. And getting to the truth requires both being a careful scholar, but in order to persuade people that you have gotten towards the truth, you divulge your sources of funding, you make the data available publicly, you share requests for data, and you sort of practice what I call open science. And what I'm hearing sort of is that the norms in the legal academy are something different. And it implies that as I think about the question, what can academics do, what's the academy's role in evidence-based policymaking, it suggests that there's a whole host of some institutional problems to work out for the legal academy in playing an effective role in evidence-based policymaking. One of which is what are these clear, what seems to me from the outside is a conflict of interest. If you're working for somebody, you should divulge that you're working for them. And the second is the notion that what the legal academy was founded on was the idea that you're going to advocate, and we teach people to advocate. Or not we, but the legal academy teaches to advocate. That's not about getting to the truth. That's about serving your client. And that's the task of the legal academy. That puts the legal academy in a very difficult position when it tries to do social science, which is about getting to the truth. And I think that one thing that the legal academy is going to have to work out is how to draw some bright lines about which of the two enterprises people are engaged in, and when are they engaging in one, and when are they engaging in another.
So let me, I noticed that our time is moving towards the very end, so I'll just mention, because I'm here as a commissioner at the International Trade Commission, where we consume a lot of this type of work because it helps us in our decisions, I'll just mention that we A big part of our docket is, of course, to also generate economic studies. So if we were asked to study these issues, we would enjoy doing that, and we greatly enjoy working with the other parts of the government and with the academy. And so I have learned a great deal from each of you, as I hope the audience has, and I know that I look forward to the possibility of working with you and others in parts of the government and parts of the academy on our studies and our research and our decision making. So I hope the audience will join me in thanking these panelists for this excellent discussion.